Mm. Thanks for joining. Just waiting for others to join in, and I'll be adjusting screen names to reflect party affiliations. So it does take a little bit of time, but hopefully we can get started as close to 10 a.m. Oh. Hmm. Okay, looks like we have all the parties in the room. We have one person connected on the phone, so I'm assuming that's someone listening from possibly a member of the public observing, which is fine. If you have no internet connection, we'll just keep you muted then. Appreciate you for joining in. And I think we're all good to go. So just so you know, it takes a little bit of time to get people logged in here. I just put we're calling the party or participant identifier before your name. That just makes it easier to see who's talking and who they belong to. Um, and that should match what we have on the notice. The pre-hearing conference is it's listed there as party identifier. That's probably a vestige from past language, but I think participant because no, we don't have staff on there this time, but it'll see some changes there in the future, but not a big deal. Okay, so I think we're pretty good. All systems are running, so let's get started. Get on the record. This is docket 6630 TE 113, the application of Wisconsin Electric Power Company for approval of its very large customer and bespoke resources tariffs. My name is Michael Newmark, the Administrative Law Judge for the Public Service Commission. We're connected on Zoom with the parties and commission staff in attendance. We're also live streaming on our YouTube channel. That will also become an unofficial recording of the proceeding today. The official recording will be in the transcript that we're creating. And let's get started on the record with appearances. I'll view the service list here. We'll just start down the list in alpha order. Who's representing Cub today?
Good morning, Daniel Narvi on behalf of the Citizens Utility Board.
Okay, Clean, Wisconsin. Oh, you're muted, Katie. No, still not hearing you. I can probably unmute you from my end. Hang on. There you go.
Solo with Clean.
Oh, now you're all right.
Did you hear me?
Well, let's just go off the record. Yeah, you're just kind of flickering there. Maybe there's some sort of delay.
Okay.
I think it's a little better now. So why don't we get on the record, just have you answer appearing for Clean, Wisconsin.
Katie Nicola.
Okay, great, thanks. And so just so you know, you can go off the record for this. So because we try to run these hearings sort of like in the room, you should have your microphones turned on. So in case you want to object, that's usually our practice is to have microphones on, so you can object in time. That's what I believe. I mean, that's in the FMO since we started the Zoom hearings. So I don't know if we're just forgetting or if if people are misunderstanding that. It's just for your benefit, I hope. If you need to mute for some reason, feel free, but I think it's a general rule you want to stay unmuted so that you can interject an objection. That's kind of the purpose behind requiring that. So, all right, let's continue on with Cloverleaf Infrastructure.
Your Honor, Richard Heineman, Boardman Clark, appearing for Cloverleaf Infrastructure, and we may also have the company's principals or one or two of them. I'm not sure because I can't see all the members or the participants, but if they are on, they can indicate so.
Okay, but you're representing Cloverleaf
Yes.
Infrastructure today.
That is
And
correct.
I don't think I heard you say your name on the, oh, you did. Okay, I see it
Yeah.
on the transcript. Okay, great. Thanks. Thanks, Richard. All right. So, Environmental Law and Policy Center.
Good morning, Your Honor. Katie Duckworth and Brad Klein for the Environmental Law and Policy Center.
Okay, see you there. Thanks. Microsoft Corporation.
Good morning, Delaney Brewer with Frederickson and Byron for Microsoft Corporation.
Public Service Commission.
Evan White's appearing on behalf of the Public Service Commission. Also with me this morning is Michael Garcia. Good morning, everyone.
Okay, thanks. Sierra Club.
Good morning. This is Priyam Desai with Sierra Club.
Let's go. Okay, it's off the record. So you're also, are people getting her connection correctly? Maybe it's just me. You're able to hear? Okay, okay.
Are you able to hear me okay?
Okay, let's back on the. Yes, yeah, it just seemed like when people were starting to speak, it just kind of was choppy at the beginning. So I don't know, maybe it's just a computer glitch here. But thanks. So on the record then, it's Advantage Data Centers.
Yes, Your Honor. Tom Malooly from Foley and Lardner representing Vantage Data Centers, WEPCO Acquisition Company, LLC.
Okay, great, thanks. And Walnut Way Conservation Corp.
Good morning, Krista Westerberg of Pines Bach for Walnut Way Conservation Corp.
All right, thanks. And Wisconsin Electric Power Company.
Good morning, Your Honor. Attorney Patrick Proctor Brown, representing Wisconsin Electric Power Company. With me are attorneys Fortune, Wilson, and Phillips.
Great. And Wisconsin Industrial Energy Group.
Yes, good morning, Your Honor. Steve Heinzen, representing the Wisconsin Industrial Energy Group.
Okay. Just off the record, so you were choppy on my end. Again, was anyone else seeing that? Or is it just me? Okay. All right.
Your Honor, I think it might be on your end. I heard it just fine unless.
Okay. Yeah, I think that what I have here is telling me I have an excellent connection, so I don't know why that's happening, but okay. Well, we'll move on. I think that'll be fine. As long as our court reporter can hear us all, we're in good hands. So great. Thanks everyone for joining. And so let's get back on the record if we were off just now. So we're here for the pre-hearing conference. Welcome everyone, old and new to our process. I think I see a few new faces here. The pre-hearing conference, we sent out the pre-hearing conference notice on September 26th. So I do appreciate everyone getting together here today. I know commission staff had shared a draft issues and schedule prior to this point by email, and we did get some responses back. And then the notice of pre-hearing conference was generated because an agreement could not be had informally. Then the notice of pre-hearing conference, basically we're here to determine the parties, the issues, the schedule, and any other matter that will facilitate the proceeding. So we do have the parties identified. There was an order already issued on that, and there's been no new request to intervene. So I think we're all set with our list of parties. The issues, there was some controversy there, so we can discuss that. But basically, the way the process will work is I'll hear arguments today and decide on these matters here. Then a written order, we call it the pre-hearing conference memo, that'll come out in the near future. But just so people know, if we agree on a schedule, if whatever I order, I guess I should say, will be in effect today, and then the order will demonstrate or record the decision in writing, but especially when it comes to the schedule, you want to operate under that schedule, because otherwise that's how we always do that, because it just we need to know what the schedule is before the written order actually gets issued. So at least operate under that assumption that I've made my decision today, and then the written order will just memorialize this. So in terms of issues, commissions, this is what I'm presenting here is, I believe, the commission staff's proposed issue, two issues, A and B. And there was some controversy on that. So I think we could probably hear first from the applicant on what the maybe the concerns about that issue are. So why don't you go ahead?
Thank you, Your Honor. We do have some concerns with the issues as presented on the screen and in your pre-hearing notice. Our position is the issues should track the statute. So this is an application for a new tariff under WSStat 196.19 and WSStat 196.192. And we're not sure where these issues came from, but they clearly don't reflect those two statutes in their entirety. Particularly B3 and B4 have really no bearing on the standard at issue in 196.192. They don't come from the pre-hearing, the commission's order opening this docket either. And our position is that 3 and 4 would turn this into some sort of IRP. So we proposed alternative issues that very directly track the statute. I believe, Your Honor, you have our email that lays those out. And we would say the issues for this proceeding should be: do the proposed tariffs satisfy WSStat 196.1922 by resulting in customers receiving market-based compensation for voluntary interruptions of firm load during peak periods of electric use, including market-based pricing options and options for individual contracts that allow a retail customer through service from its existing public utility to receive market benefits and take market risks for the customer's purchases of capacity or energy, and not harming shareholders of the investor-owned electric public utility or customers who are not subject to the rate. That's nearly verbatim the standard from WSStat 196.192, which the commission has said is mandatory. Our analysis of the statute too suggests that that's a mandatory directive. The commission shall approve a tariff if it meets those three standards, and there's really no discretion involved in that. So we frankly don't understand where B came from. We don't understand why 196.022 is in A or 196.20 is in A. Those statutory references don't belong in this proceeding. But if necessary, we wouldn't be opposed to including 196.37, which is the commission's authority to determine whether any rates are unjust and unreasonable, which would be implicit in our eyes in whether the tariff harms shareholders or existing customers. So that's our position on the issues. I think it's very straightforward and tracks the statute, and we don't see any role for B3 or B4 in this proceeding. I guess I would add there, Your Honor.
You also mentioned, sorry.
So I would add, Your Honor, it's not as if 3 and 4 are not going to be addressed by the commission. That's not our position, right? So every infrastructure project will be subject to its own construction docket, whether that's a CA or a CPCN. So B4 is relevant to those construction dockets, which this is not. Every bespoke resources service agreement will come before the commission for specific approval. So that's another place where the infrastructure will be evaluated by the commission. And customer load is relevant to both the construction dockets and in Wisconsin Electric's rate case proceeding next year, to the extent we're setting rates or allocating costs that flow through to these tariffs or to other customer rates. So it's not our position that this is outside the bounds, that B3 and B4 are outside the bounds of the commission's jurisdiction. That's not at all the case. They are going to be part of other proceedings before the commission. They should not be a part of this tariff docket. There are other proceedings pending before the commission where they are evaluating individual contracts. And so maybe those two issues would be relevant to those proceedings. But they aren't relevant here.
Okay, all set. Yeah, thanks. Just make sure you're finished because I'm not hearing you quite in a smooth presentation. So
My apologies, Your Honor.
no, it's not your fault. It's not your fault. So I did want to ask you one question, Attorney Proctor Brown. You mentioned Statute 196-19, and I think that's not on your issues list. Can you just because you referenced it, I just want to make sure I understood why that's not on your list.
There's not much of a standard in 19619, right? So 19619 is just the requirement to file. And so that's what we've done. We believe we've complied with that. If someone wants to contest whether we've made the filing, I suppose that's possible, but we certainly have made the filing. That differs from 196.20 to our mind. That's related to changes in tariffs and has a lot of requirements for when rates change for existing customers. That's not what's happening here. These are new tariffs. So 196.20 shouldn't apply. Thank you, Your Honor.
Okay, I just want to be clear on that. Okay. Yep, thanks. All right. Okay, so thank you for presenting that argument there. I appreciate it. Any response? And I know that so commission staff is proposing this set of issues, but I'd like to hear from interveners if they have opinion on that. And I think I inadvertently may have deleted or closed my service list, but I know that Citizens Utility Board was top on the list. So let's just go through the list and see if there are any responses from interveners, starting with Cub.
Thanks, Your Honor. As we indicated in my email that responded to staff in the first instance, we don't have a big problem with an issues list that closely tracks the statute as the applicant has suggested. Although I'm not sure if an issues list is really useful, if it simply mimics the statute. I guess that's a question for the commission to decide. But we do fundamentally disagree about whether sub-issues 3 and 4 are relevant here, to the extent that you, Judge, feel inclined to decide that here, which I don't think you have to do. We're just setting an issues list, not just deciding on the scope of every topic of discovery or evidence or briefing in the case. The statutory factors include potential harm to customers, and we're not asking the commission to decide this new tariff in a vacuum. We know that there's significant new load that's proposed and issues that relate to potential for cross-subsidization with customers, potentially paying costs of new generation or transmission assets, new infrastructure, the risk of stranded assets. Those are central to the inquiry here for the commission. This is the first instance where this commission is being called on to address a large load tariff like this, but it's not a new issue nationally. Commissions around the country are addressing questions like these. They're considering at least some of the issues that are delineated in the proposed issues from staff, and we think they're appropriate to consider here. Again, do we think that they need to be expressly spelled out in the issues list here? Probably not. But to the extent that the applicant's asking for a ruling that these are, off limits in this proceeding, we disagree there.
Mm-hmm. Okay, yeah, I think that may be the nature of the situation here, as far as I mean, although I think our mutual understanding is that the issues we set here determine the scope of the factual investigation in the case, and in terms of citing statutes, it sets the standard for the commission's determination of the legal standards. So I think putting something, so if we cite a statute, I think if people are familiar with some of our construction cases, CPCN cases are very simply cite the statutes and rules and allow argument and presentation of cases of the facts within the parameters of the statute as they apply, which actually does get complicated sometimes when people have different theories of the what the statute allows. In rate cases, we're citing some, I guess we just really just say, is the rate reasonable? And we give sort of a broad generic box to put in all the arguments that we use to determine reasonable rates. But here, I think we are delineating what would be acceptable in terms of relevant and relevant evidence, I suppose, applying the applicable statutes. So we want to make, so I think because there's a controversy about the list, about the issues, I'm being asked to make that decision now as to what's the scope of the investigation and what, I guess I'm not saying that there aren't any other statutes that may apply when you're creating a legal argument about the case. But in terms of the factual investigation, I think if you get a discovery request that is outside the scope of the issues list, the person who believes that that's outside the scope of the respondent will argue they don't need to answer that discovery request. It's irrelevant, it's outside the scope of the case. So this does have meaning. This process does have meaning. We're not just doing this for, as an exercise in utility, I hope. So the idea is to bear down on this and to say, well, what will be allowable factual investigation in this case based on the application and the issues that it raises. So with that understanding, to the extent we want to permit certain things and make sure they're not excluded by legal argument, it's important to put them on the list so that we don't fight ad nauseum as to what's relevant or not. So with that being said, I think that's, and I can have commission staff speak to this more, but I just wanted to let you know in general that's how I would perceive this process going. It's not simply it's not something we can argue later. I think we're arguing now what is allowable evidence, what's the allowable scope of the investigation. So I don't know if you have anything else to add, Attorney Narvi, or we can go down the list from here.
I just conclude then, in light of what you just said, by emphasizing that we do believe that those sub-issues listed by staff are going to be relevant. So to the extent that we're deciding now whether they're going to be, kind of fair game for either discovery or intervener's testimony or briefing, we'd ask those issues to be included. And I'd also suggest that there are going to be, I think, inevitably some sub-issues that we're not going to be able to exhaustively list every single, factual or regulatory issue that might come up. And so although I appreciate that you're saying we want to tackle things now so we don't have to later, there's inevitably going to be some kind of, discovery or expansion or contraction of issues throughout the proceeding.
Okay, understood. All right, Clean Wisconsin.
Thank you. Can you hear me okay?
Yes, I hear you now.
Great. Clean Wisconsin agrees with everything that Cub said here, and I think to be clear about this, supports the issues list as proposed by staff. I think it's really important to not limit the scope here at this early stage with this being a new situation. We're going to be seeing a lot more of these very large load customers coming in, and I think it's important that the commission has the ability to examine the issues kind of broadly and not be artificially limited in the scope of this investigation. Thanks.
Okay, thanks. Any comment from Cloverleaf?
Sure, Your Honor. Unfortunately, I've lost my visuals, but you can hear me, correct?
Yes.
Okay. No, Cloverleaf strongly endorses the arguments that the applicant made. We think that the market-based tariff statute that was referenced addresses the issues that were just raised by both Cub and Clean Wisconsin, insofar as one of the standards that's most germane to the issues that they're trying to raise have to do with harm to shareholders of the investor-owned electric public utility or customers who are not subject to the rate. And so we understand that those are important issues, but we wholly endorse the concept that what is happening here is the approval of a tariff that will allow precisely for the kind of insulation of impacts of other customers to occur when you have a large load like the proposed data center. All the issues pertaining to the infrastructure that are going to be required to serve that data center, those, as was referenced by Attorney Proctor Brown, those are going to be subject to separate proceedings where those can be reviewed. So it's not that those are not germane, but what is at issue here is the extent to which the proposed tariff structure is going to allow service to this large load customer, to this data center, without harming other customers or harming the shareholders of the company and the others, the other standards that are referenced in that statute. We think that that will allow for a robust discovery process, and it'll be up to the applicant to demonstrate how it is that the proposed tariff accomplishes all that. And then the issues pertaining to infrastructure, those can be addressed in other proceedings. If they're allowed to be addressed here, we think that that's going to provide an opportunity for substantial delay and information that'll be extraneous to the proceeding at hand.
Okay, thanks. Environmental Law and Policy Center, any comments?
Yes, Your Honor. Environmental Law and Policy Center supports the list as proposed by staff. We believe those issues are appropriate to consider in this proceeding and support the comments of Clean Wisconsin similarly. Just to note, ELPC is in a number of other large load tariff dockets in the Midwest, and these are issues we see in those types of dockets. So I think that just goes to say that the issues in the list are illustrative of ones that are relevant to reasonable and just rates in the standard. So we support it as proposed by staff. Thank you.
Okay, thanks. I'm going to skip PSC. I get the last, at least, well, let's hear for intervener first. I don't know if you'll have the last word. Let's see, Sierra Club, any comments?
Sierra Club likewise supports the PSC's proposed issues list. I don't think that we have anything to add beyond what Cub, Clean Wisconsin, and ELPC have already put forth, but we do generally agree that this is the appropriate time to kind of broadly consider all of the potential impacts of this tariff, these tariffs collectively, and which is why we think that the issues list that the commission staff has proposed is exactly appropriate for the commission to consider at this time. Thank you.
All right, thanks. Vantage, comments?
Thank you, Your Honor. We support limiting the list. In particular, what we're focused on here is B3 and B4. and eliminating those two. What the Cub Attorney Narvey was concerned about was harm to customers, and that in fact is in B2. And so one of the things that this tariff and what the commission should appropriately look at is, will allowing a very large customer tariff, is it built in a way that protects ratepayers? Will the customers under the VLC tariff actually have to pay everything so that other customers are protected? That's a crucial issue. It's a huge issue. We can spend a lot of time on that issue, and it's appropriate because it's part of the statute. The other issues that Cub and Clean Energy, EPLC, and Sierra Club, they've all said, well, this should be broad. We should be able to consider everything. And why? Because it's the beginning, and we should just not be artificially limited. But in fact, it's not an artificial limitation. It's a statutory limitation. It's what do the statutes direct us to do in this particular proceeding? All the other concerns that everybody else has had about the industry, or who might these customers be, and what kind of specific things are going to happen, those will all be considered by the commission and by all of us at later proceedings. But the point of this, the point of having different statutes and having different proceedings is so that we can do things in an orderly manner. And I think the way to do this in an orderly manner is to eliminate B3 and B4 from this proceeding so that they can be appropriately considered and focused on in other proceedings. I know, Your Honor, you may have skipped Microsoft as you were going down the list.
Oh, I apologize. Did I? Wow, I think I read it. I saw it and I didn't say it. Sorry about that. Thank you for noting that. So let's hear from Microsoft next. I apologize for that.
No, thanks, Your Honor. I don't mind hearing everyone else first. Microsoft generally agrees with the applicant and Cloverleaf as well as Vantage. And I think specifically, again, with respect to 3 and 4, and really to the extent that B3 is intended to reflect 196.02, I think that it misrepresents that language. Actually, that language, allows the commission to create different classes of service based on these factors. And so the question would be whether the class as proposed in the tariff is reasonable, considering how the class is defined and limited based on the quantity of energy, the time when used, et cetera. And the language here seems to broaden this into specific customers or potential customers' usage data. And just to kind of set the stage, the reason that that's a concern here is because Microsoft at least takes data protection very seriously. And among its closely held data is load data. It's highly confidential, it's trade secret. And we believe that to the extent that this issues list is too broad, it could allow for a bit of a fishing expedition here into items that aren't relevant to this tariff proceeding at all. We should be looking at the structure of the tariff here. And you have some great interveners here who can add a lot of quality to this docket. And that type of broad issues list and that potential for discovery that you spoke about earlier, and some of those discovery disputes could really discourage participation in dockets like this in the future, which I don't think is a path we want to go down. So I think specifically 3, and I think with respect to B4, I don't want to be too repetitive here, but there's an obligation to serve, and what infrastructure is necessary for the utility to do that is determined in those construction dockets. So it's just simply irrelevant here.
Okay, thank you. All right, we'll get back on track here. Okay, we have Wisconsin Walnut Way Conservation Corp.
Thank you, Judge. Walnut Way supports the issues list as phrased by staff and agrees with the comments of Clean Wisconsin, Cub, and Sierra Club, and ELPC. The thing that I would add is I think we heard from Vantage that this could the issues list as phrased by staff could make things a little too broad, but I think the issues list actually will help organize the docket and keep the parties focused on the issues here. Although per Cub's comment, it does note that there are other issues that may be relevant other than these 1 through 4, but at least having these articulated can help focus the docket and prevent discovery disputes in the future, and keep everyone more or less rowing in the same direction. So we think it is helpful to have this articulation here. I think they are relevant under the statute. I think they are relevant under the commission's broad authority that it's afforded in these matters. Thank you.
All right, thanks. And I think.
Yes, yeah, thank you, Your Honor. As I, thought about this over the last couple of weeks. I guess the way that we had seen this is that if they were identified like they are in the commission, as commission has proposed here, totally fine. And if they were not and they're pulled out, well, it wasn't that big of a deal because all 4 would be subsumed into A anyway. All 4 would be reasonable and fair to be exploring. Now I see, as a consequence of today's conversation, that's not how everyone is looking at this. And so I would say that I agree with Attorney Narvi of Cub and the others who have requested or asked that the issues list be maintained as it is here now with 1, 2, 3, 4. I think 1 and 2 would be in a regardless if it is specifically identified or not. I guess I'll hold off on 3, but at least with respect to 4, the commission is supposed to, in part in reviewing this is, will other customers be harmed in any way? And I don't know if that can be reasonably done without the commission taking into consideration the infrastructure, the transmission that will have to be built in some cases to serve, the parties or the customer who would be taking service under the tariffs. I know there's a little disconnect there, but but certainly there will be costs that come through to customers, come through, the transmission that are not that ought to be considered by the commission when deciding whether or not customers are going to be harmed by the tariff. And I guess I'll leave it there.
Okay. Yeah. Thanks. Okay. Let's hear from commission staff. I think we have all the interveners, correct? Yeah. So commission staff, any comments?
Thank you, Your Honor. I guess the benefit of going last is I don't really have a ton more to add. I think from listening to the positions of everyone, I think everyone is in agreement that under 196, 192, one of the supreme considerations is whether or not there's harm to either shareholders or non-participating customers. My worry is that constraining the issue statement to just that statutory language does not create a rubric by which harm is measured. Like, how does the commission evaluate whether or not there's harm to non-participating customers? And I think that's really the intention of sub B, is to get into some of those specific areas by which to evaluate where might there be harm or non-harm, perhaps to non-participating customers. Is this reasonable in terms of its allocation of costs between the cost causer and the cost payer? So that really is intended, I think, to help flesh out some of those areas of discussion so that the commission can make an informed decision of whether or not there is or is not harm to non-participating customers from this particular arrangement. I would just also note that under sub B, it does say how might the following considerations apply to that determination. So there's sufficient flexibility for each party to make an argument as to whether or not they think that a certain area applies or doesn't apply. It's not a prejudgment saying that these are the areas that will be considered, but it provides sufficient flexibility and kind of direction to guide the fact gathering and record creation process so that at the end, the commission has the information it needs to make an informed choice on this matter.
Okay, thanks.
Your Honor, may I respond to those arguments?
Sure, yeah, go ahead.
I want to address Attorney Weitz's comments first because I think someone mischaracterized the statute and what the commission has said on what the statute means. So in docket 6690 TE 113, the commission said the commission is required to approve market-based rate proposals that are consistent with the statute, except that the commission may not approve a market-based rate unless the commission determines that the rate will not harm shareholders of the investor-owned electric public utility or customers who are not subject to the rate. The commission did not say that it was considering infrastructure investments, did not say it was considering customer load, did not do any of those things in that docket. There's no precedent for what Attorney Weitz has just argued for, and it's inconsistent with the commission itself has said. So I'm a bit surprised that commission staff is arguing against what the commission has said before. Setting that aside, the framing of B is wrong as well. So we do absolutely oppose 3 and 4, but the question under 196.192 is not what are reasonable rates. The commission does not get to write on a clean slate here. They do not get to adjust the customer classes. The tariffs that are proposed by applicant in this docket are the product of 2 years of negotiations with some of the biggest companies in the world that are going to be making the biggest infrastructure investments into the state of Wisconsin ever. So this is not the case where the commission and these interveners get to come in and say, here's a different tariff structure. That's not the evaluation under 196.192. So the framing of B is inconsistent with the statute as well. It's inconsistent with commission precedent, and it just does not stand, Your Honor. So if we're stuck with the kind of colloquial language that staff has proposed, there need to be revisions to B, and 3 and 4 need to be stricken. I don't want to get into what future discovery disputes will be. You know, those will be taken up on a case-by-case basis and subject to further proceedings. I am sure that we will have disagreements about what constitutes harm to existing customers, and those will come before you in due course. But we need to be sticking to the statute, and we need to be sticking to commission precedent. I want to bring up something that hasn't been said directly, but it is implicit in some of the comments from the very large customer representatives. Confidentiality is a huge concern in this docket, and this is the only docket where it's conceivably relevant that 2 customers' load data could be cross-pollinated. If you allow 3 in, this group of customers, could have access to other people's load data. It's not necessary in this proceeding, and it should not happen, right? These are competing entities, some of the largest companies in the world, right? That keep these secrets highly confidential and have very serious concerns about cross-pollinating that data. It just should not happen in this docket, Your Honor. It can happen in individual infrastructure dockets, which will come before the commission. Those will likely be limited to a single very large customer and will not involve the kind of cross-pollination concerns that arise in this docket, where we have multiple large customers, and can be more easily managed in those dockets, which will come before the commission in due course. So I just want to raise that issue that, if there's some concern about evaluating customer load, that should be done on a case-by-case basis when we're applying for specific infrastructure projects. I also want to address Attorney Heinzen's comment about how the infrastructure could go to harm. That's never happened before, right? So in the EITM docket, which was 1 customer, there wasn't evaluation of the customer load and the infrastructure necessary there. That's outside 196, 192. But what he's talking about is kind of the scale of harm. and that will come forth in each individual infrastructure project. What the focus of this docket should be is whether the different categories and the structure of the tariff cause harm. It doesn't matter to that evaluation that the infrastructure will be, 100 million or 1 billion. The way that this tariff is structured passes through costs and ensures that the customers will pay for the infrastructure necessary to serve their load, no matter how large it is. So the scale of the harm just does not go to the statutory standard here and shouldn't be a part of this proceeding. So I would rest on those comments now.
Okay, great, thanks.
All right, one more.
I did have a question. Oh, go ahead.
I apologize, Your Honor. I got an elbow. We also heard about proceedings in other states, and the reality is those are occurring in other states under other statutory standards. So what Arizona or Virginia does in their proceedings has no bearing on what the commission should do in this statutorily constrained and mandated process. We're doing it different here in Wisconsin, and that's one reason why these very large customers are choosing to invest here. They appreciate, my understanding is they appreciate our regulatory environment, they appreciate our speed to market for these infrastructure projects, and they appreciate our access to resources here in the state. So what Virginia does is just not relevant to what we should do here. Thank you, Your Honor.
Okay, great. So I did have a couple questions. I maybe need some more information, clarity from the applicant. And I guess the question is, I do see there's been some debate here about the use of, or where the information regarding an individual customer may come into play, and the appropriate timing for that in terms of a individual contract evaluation. And as far as I've seen in the application, there's the very large customer tariff, an agreement template, and the bespoke resources agreement template. So the way I was perceiving this application is that there is an agreement being reviewed by the commission at this time in this docket, a template version, I suppose. But to what extent the commission is allowing that to be used, what exactly is the intention of the applicant in terms of the template proposal vis-a-vis the subsequent individual contract that I guess what would be happening is that would be proposed in another docket for approval. Can you explain a little bit about that?
Yes, thank you, Your Honor. We are asking for approval of the templates, and the commission could find that particular provisions of those templates violate 196192 or need to be conditioned to ensure that there isn't harm to shareholders or customers. Once that's done, as any electric service agreement that the commission has approved before, it becomes the basis and the strong presumption that that will be the agreement that the very large customers enter. But there could be changes, right? And so each of those individual contracts, when they are entered into, will require approval from the commission. I don't know whether it's in this docket. I think it probably makes sense to keep it in this docket, or maybe some limited proceeding to approve each individual contract. But once that's done, particularly with respect to the bespoke resources, the infrastructure will be known, and there can be some investigation into, how that infrastructure is supported by customer load, how the scale of that investment, how it will be flow through the bespoke resources service agreement on its own. But each of those contracts specific to each bespoke resource will come back before the commission. And my reference to individual contracts that the commission is reviewing right now relates to another utility where they have chosen a different structure where they have put directly in front of the commission the infrastructure and customer load in their docket. That's not the case here, right? So my understanding is these are the same issues that were proposed in the other utilities docket, and they may apply there, but they don't apply here because of the structure of our tariff and each of the individual contracts coming back before the commission. And that's not the only place, Your Honor, right? So as you know, each of those construction projects will be subject of a construction docket, right? So whether they get built in the first instance is under the CPCN statute or the CA statute, where those issues would be relevant to. But we're not proposing any specific infrastructure in this docket. We're not even really talking about individual customers. We're talking about the structure of the tariff.
But there is a customer that's before but this case does not involve approval of a contract for a specific customer. That's not the intent of the utility.
No, Your Honor. It's the form of the agreement that has been negotiated with multiple customers, and we're not even sure as we sit here today whether the customers that we've negotiated and are represented in this docket are the only customers that will take service under this tariff, right? So the idea that we need to have some sort of broad understanding of what the customer load and infrastructure will be required under this tariff. I mean, you don't do that under the CP1 tariff. That's just not what you do in tariff proceedings.
Okay. I did want to address confidentiality to the extent that we are going to be looking at customer information. This is a certain type of customer that we're dealing with in this tariff. I'm not going to call it a class of customer. I think the commission would need to decide that, but a certain type of customer that I believe, from what I've seen, is different than previous types of customers. But in terms of confidentiality, if the commission or commission staff were under these proposed issues to ask questions about the load and the quantity of energy used, time used, purpose, this sub B3 issue, all that information would be subject to confidentiality protections. That we are all familiar with and I've worked with for, I don't know, probably a century. We've kept the information, business and competitive information under wraps at the commission. We would have also the ability to keep that from each of the separate customers in terms of their in terms of having attorney's eyes only, third party, non-party attorneys who are only be the only ones allowed to look at that information on behalf of the customer, the potential customer. So there's certainly a standard practice for protecting information and protecting the sharing of information between competitors should that become an issue. So I appreciate people raising that as a concern, but we can address and will address that concern and lock it down to make sure that competitors do not get an unfair advantage, get any information from each other that they consider competitive or business trade secret. So is there anything else from anyone?
Judge, can I briefly respond?
Okay.
Yeah, I think Daniel Narvi for Cub.
Oh yeah, go ahead.
Yeah, look, I think Attorney Proctor Brown's comments kind of lay bare the stakes here, right? These are enormous investments, unprecedented in Wisconsin by some of the largest companies in the world. And the commission's past practices in tariff cases that are different in both degree and kind have limited guidance for the kinds of risks and potential harms to customers that are at play here. On the other hand, the customer harm factor is one that is consistent throughout the cases that are being considered around the country. So I think absolutely the types of issues that commissions are grappling with as they try to address the risk of customer harm, things like cross-subsidization and the risk of stranded assets are things that should be considered here. nobody here is trying to transform this into a construction docket. We don't have time to do that, as we'll talk about when we get to the schedule, right? This is a compressed schedule. We have limited time to do discovery. And nobody's asking for the commission to make the kinds of decisions that they would do in a construction docket, simply that the commission should not blind itself to the kinds of possibilities in terms of infrastructure investments, including known publicly disclosed facts, right? That the commission needs to take into account when considering the structure of this tariff.
Okay, thanks. So I can give us a little bit more guidance on this. I can. So the procedural history in this case is a little different than another, I guess, sort of a sister case dealing with similar issues, which is 6680 TE 115. It's Wisconsin Power and Light Company's application to approve an individual contract rate service agreement for a large load customer in Beaver Dam. And that case, we've seen requests to intervene and requests for a contested case hearing, similar to what we've seen in this case. However, in that case, the applicant chose to object to or oppose the interveners, both the request for a contested case hearing and the request to intervene. So now the commission had, before I was able to, or there really wasn't a formal way to address that contested case hearing request before the docket was open. It was filed before the docket was open, and I really don't get involved with these cases until the commission opens a docket with its notice. So, but what the commission chose to do was to open both of these cases as proceedings, contested cases under Wisconsin statute, chapter 227. So really the request to hold a contested case was moot. And so I didn't address that in this docket, in the instant docket. I simply approved the requests to intervene. They were unopposed in the WEPCO case. So I didn't get into the nuts and bolts in the same way that I did in the Power and Light case with respect to whether there should be a contested case and whether the requests to intervene were valid given the procedural posture of these cases. So, but I think the decision in 6680 T 115 is informative here. I think really touches upon the same issue. And since I articulated this very clearly, I'll refer you to that and also kind of give you a summary. But in particular, the decision with substantive, the substantive decision was the order on the requests to intervene, and that's has a PSC number of 560220, and I can share that on the screen. But I think it's important to review that because I do want to be. I think the same issues are being raised in both cases. I know there is a different form. The applications have come in different forms, but I think the legal issues are similar enough that the decision here in the Alliant case and the Wisconsin Power and Light case is relevant and informative. But also, what's important to note is that we have a process here where we've been looking at past commission practice, which isn't precedent per se in administrative proceedings, but looking at past commission practice, the commission has taken steps to review the market-based rate contracts in a very expedited fashion in some instances. And I don't think that can really be used as a model here. And what's important to note is that the commission didn't even open an investigation in some of these cases, just simply had a comment period and decided to approve changes to customer individual contracts. Here, I think the difference is we see the commission opening a proceeding. And I think that begs the question, we don't have the commission's statement of the issues in this case. The notice of proceeding it issued was a sort of a standard boilerplate style notice. But I read the fact that the commission moved to open a proceeding as having meaning. And that meaning, I think, is because of the situation we're seeing in the customer type is distinguishable from what we've seen in the past. So because of that, I think, while the commission's taken more of an informal review in the past of these contract approvals, when it comes to the issues being presented here and in the context that it's in, I think the commission has indicated a desire to collect more evidence, more information before it makes a decision on the application. So, and the fact that the application came in citing a certain statute doesn't necessarily mean the commission is bound by following only that statute and that process. In order to affect its authority, it should have the discretion to review this in the totality in its context, and I believe it's indicated the desire to do so by opening a proceeding and inviting the more robust creation of a record here. So, to that extent, I think it's appropriate that we have a broader scope of issues, and that the commission, and then for that reason, I would approve the commission staff's proposal. I think it's important. I think it's important to recognize that the citation to Wisconsin statute 19602 sub 2 is looking at the nature of the customer, to the extent that I don't know to what extent that needs to be specific, but I think the information that the commission would want to see in that situation is this a distinct customer class? And I think it needs to make a decision on that before it moves forward, and allowing the connection of these large customers into the system. So I think it's important to give the commission that opportunity to make that decision. And so that the reasons why commission staff has so that's related and important information to why commission staff has included those statutes, and I think it's a valid investigation in this case. So with that, I will approve the staff's issues. I guess the B4, the infrastructure improvements necessary to provide service for the customer. I'm not sure, from what I've heard from the parties, I'm not sure how that would actually be, how we would proceed with that issue. I think it's enough now to let it stand and have it be have parties allow parties to present evidence on that, but I'm not sure how what that's actually going to look like. I can't imagine it, I guess, is the problem. And if I don't want to preclude that information from the record at this stage, but I'm having some trouble sort of imagining what that is and what it would entail. But that cuts both ways, because I just don't know what we'd be missing if we don't allow that type of evidence. I'm just not sure what we're actually going to collect that would be probative. So I guess I would say that issue I would need to see something. I think we'd have to be very particular about that and careful about what kind of I don't know. I don't know if staff has any more information about that, just so we have a little more of a can put a little more meat on the bone in terms of what that's intended to elicit?
Sure, Your Honor. And I guess this goes to something that was discussed previously where the applicant was arguing that any sort of acquisitions or infrastructure dockets would each be considered individually. However, as we all know, when approving infrastructure, whether that be a CPCN application or a CA application, the commission doesn't decide the recoverability of costs. So to Your Honor's question, I'm not sure if it helps add some clarity if there was a reference to costs. I think the thinking as far as B4 is really the cost of those infrastructure improvements and how the proposed rate prevents any harm to non-participating customers. Because due to the size and scope, I think the nature of the infrastructure improvements are at least quantitatively different than perhaps other customers. So I don't know if that helps add some clarity there.
Okay.
Your Honor, can I respond to that?
Yeah, sure, of course.
So I think Attorney Waits' presentation there points out why we should not go with the staff's issues. You know, if we're not understanding what the language means, and he said, I think the idea is, right? So this is obviously a game of telephone between Attorney White's and the docket coordinator or whatever staff members are preparing this docket to us. And we should not have to guess. Staff is not a party, right? So they should not be, their understanding as transmitted through Attorney White's should not be how we structure this docket. All parties will be able to make arguments about what the harms are to existing customers or shareholders if we stick with the statutory language. The statutory language is capable of interpretation according to ordinary canons of construction that everybody can argue when these issues of discovery or the scope of the proceeding, motions to strike, or whatever comes up down the line happens. But we shouldn't be basing the issues list on a game of telephone back to commission staff.
Your Honor, if I can just object to the sort of ad hominem attacks about a game of telephone.
Hang on. Okay.
Attorney White literally said, I think the thinking is. And so there's clearly somebody else drafting.
Attorney Proctor Brown, please. Okay, we're going to off the record. Okay, let's get back on. So Attorney Proctor Brown, I appreciate your comment there. I don't think we need to be implicating or accusing staff of any inappropriate or
I didn't, Your Honor. There's nothing inappropriate about that. I didn't say there's anything inappropriate about it.
All I can say is
set the issues.
Okay. So my concern is that it's not. I'm not too clear on what B4 entails. I think
which is a problem, Your Honor. That's a problem.
Yes,
we should stick with the statutory language, and then everybody can argue about what the statutory language means, not trying to divine what other people that wrote this meant here in this pre-hearing. But respectfully, I think we should be on the record if we talk further about it.
We are on the record. We were back on the record. Yes.
Oh,
I interrupted you and got off the record to interrupt you.
Okay.
Back on. Yes. I will try, especially with a pre-hearing, I will try to keep these arguments on the record. That is my intention. There may be some unintended situations where we end up speaking off the record, but I do intend to be on the record. So yeah. So I do. I see your concern, but I also see that we could argue about whether information is contained in impacts to non-participating customers. Then we'll be back to the same argument, whether sub 4 is included or not. So I'm just inclined to keep it in. We're going to be back to square one no matter what. We'll just be arguing whether it's appropriate or not. And So keeping it in or taking it out really has no effect. I'm going to just leave it in at this point. So do we need a break before the schedule, or I think the schedule may be fairly simplified now because we do have a new staff schedule here that gives a little more time than we've had before, but what are we inclined to do? Can we plug forward here? Okay.
Your Honor, applicant would prefer to plug forward. I think there's another pre-hearing coming up too. So.
Yeah, I'm aware. Okay, so how about the schedule? So we did get some responses from the parties. I was inclined to, of course, not have the direct be before the pre-hearing conference. Now that we're having one on October 3rd, we pushed the applicant direct to October 10th. The rest of the schedule, however, I think is moving slightly. I'm not really sure, but do we have any response on the new proposed schedule from the applicant?
Your Honor, the schedule in the pre-hearing notice wasn't supported by any of the parties. All of the parties agreed to the WEPCO consensus proposal, so it appears this is a legacy of staff's proposal. Obviously, the applicant direct moved to a certain extent, but the tariffs have still been pending since March. So our position is there's no reason that intervener and commission staff direct should be after the holidays. And we would direct you to our proposal with some, if there need to be adjustments made, our direct testimony is one witness that's sponsoring the application and explaining the tariff provisions and adding some very limited analysis related to transmission costs. So when this was handled in the only docket that I'm aware of for Wisconsin Electric, the tariff docket that had a contested case, 6630 TE 107, there are only 37 days between applicant direct and commission and staff and intervener direct. When we're looking at 70 days in our proposal, or I guess now 62, that's double. And we should have staff and intervener direct as all of the parties agreed in before the holidays. That then rebuttal takes the holidays, so we'll be working the holidays, and essentially gives us 30 days or so to respond to 9 intervener testimonies plus commission staff. And then we adjusted the hearing slightly to accommodate a conflict for one of the parties. So we definitely think that the schedule that all of the parties agreed to should be the schedule for this proceeding, but happy to make adjustments given the adjustment to applicant direct, so long as we stay before the holidays for staff and intervener direct.
Okay.
Krista Westerberg, I just wanted to, we didn't necessarily, Walnut Way did not necessarily oppose the staff one. We were agreed to both. So to the extent Attorney Proctor Brown said we opposed that one, that wasn't our intent. We were agreeable to either schedule. But now in light of, this discussion and applicant testimony being perhaps a little bit later, it might be appropriate to at least bump out the intervener and commission staff testimony deadline beyond what the applicant had proposed.
Okay. Any other interveners?
Your Honor, Tom
Yes.
Lilly for Vantage.
Okay,
And
let's have EDA first. Go ahead. Go ahead, Tom.
Thank you, Your Honor. We would support the WEC proposal for an earlier, being able to put in our testimony before the holidays. I think with everybody has had the basis of this since March. We think that there's no need to wait until January for people to respond to that.
Okay. Was it Steve? Are you next? Any other parties wish to comment on the? Oh,
yeah, Your Honor, Brad Klein for ELPC. Just a quick note. Did appreciate Attorney Proctor Brown reaching out to the other parties and attempting to negotiate a schedule. I think that's useful to do. We are certainly comfortable, as we agreed to get testimony in before the holidays. I did just want to note, with the adjustment of the direct testimony filing date and testimony going in before the holidays, I think it is worth the group discussing appropriate discovery turnaround times, just so we have enough time to develop the record and get discovery in to help inform the testimony. I don't have a specific proposal on that, but I just wanted to make sure that was part of the conversation this morning.
Okay. All right, sure. Yeah, I guess so I appreciate the applicant reaching out to parties and conducting or accommodating certain proposals here for the schedule. I do want to mention though, well, first of all, I guess, is there a hearing date conflict I'm seeing now? So the February 4th, the proposed hearing date, there is a current conflict with one party. Is that true?
Your Honor, it's our understanding that it's not so much the hearing date, but it's the time period between the hearing and the initial brief. And so we moved the hearing in our proposal to accommodate that lengthy absence, kind of creating more space between the hearing and the initial brief. It's not the hearing date per se, but the time between.
And it looks like the staff's current proposal matches what it had originally proposed. So who's the party that has the conflict?
Your Honor, that's Clean Wisconsin. I don't know if anyone else has a conflict, but we do.
Okay. Right. Okay. So I guess part of the information that I need to discuss here is that, well, we have the WEPCO consensus proposal. To the extent, I guess I don't know, but is it the issues that we're dealing with being broader than the issues that WEPCO prefers? I think the issue that staff had proposed came along with the staff proposed schedule. So I just wanted to make sure if my understanding would be with a broader scope, we would want to have more time. But but I don't know if the parties were envisioning a broader scope under staff's issues, or were considering using setting the schedule of the consensus proposal based on the WEPCO more limited version of the statute of the issues list. I don't know if anyone has any insight on that.
So, Your Honor, what I would say is we expected the issues to be broadened by staff and intervener direct. And that is our main issue with the staff proposed schedule. It's 14 days to turn around testimony to 9 interveners and staff is not enough time. And it's frankly just not fair to give the interveners 103 days plus all the time before since the tariffs have been filed in March, and then the applicant and anybody that wants to respond in support of the tariff 14 days. So these tariffs do need to be approved, and it's our understanding will be decided upon in Q1 of 2026. And so the only way to find room to respond to all those issues is to bump staff and intervener direct back before the holidays, which all of the interveners agreed to with us prior to filing the WEPCO proposal. So the breadth of the issues bears on this time for rebuttal, not the length that staff and interveners have to prepare their testimony.
Judge, this is Krista Westerberg. I don't know that I would necessarily agree with all of that. I mean, it's true that these docket filings have been out there, but the nature of the proceedings were not decided until more recently. And the party's ability to conduct discovery is not necessarily something that could have been done in March. To wait until the nature of the proceedings in this conference to get that ability under at least one reading of the regs. So so that's maybe not neither here nor there as to what the schedule would be, but I just want to say there are other considerations that bear on the fact that the tariffs were filed in March, and the party's ability to develop the record, since that time has been limited.
Your Honor, I think that's a misrepresentation. The case has been opened since June.
Mm-hmm.
So the regular discovery procedures apply under PSC 2, and we didn't oppose any interventions. We didn't get any requests for discovery, even from staff, until after this proposal was sent. But the proposal for the issues and the schedule has really no bearing on whether you can investigate through discovery under PSC 2 the nature of the hearing once it's a contested case. And even if it's not a contested case, there are discovery mechanisms that you can use as well.
Okay, well, we don't have to debate the law on that, but certainly people need to be a party before they can affect discovery, and but that had been issued. I issued that order on August 6th. So yeah, you're right. Now, would there have been controversies about the issues list making discovery more problematic? Maybe that's another contextual point, but yeah, I see what you're saying in terms of saying you have not received discovery at this point yet, an attempt to discovery since August 6th. Is that correct?
We have some from staff, and I think we have a generic request from WEG, but I might be wrong about that too. It might just be from staff at this point.
Okay. Well,
and none of that happened until after this issues list was circulated. So certainly staff could have been issuing discovery to applicant as soon as the application was filed.
Mm-hmm. Okay. All right. So I'm not going to penalize anyone for not conducting discovery yet, but I think So I don't know how much leeway we have. I mean, we can, of course, extend the schedule. There's nothing stopping the commission from hearing this, providing more time. And I don't know how much time commission staff needs for its and interveners need for their direct. So that's.
So, Your Honor, if I may, I reached out to Attorney Garcia to make sure that you have this email. I think it would be useful to look at the table that I put in the email that I understand you have, and adjust from there.
So so the applicant is prepared to issue its direct, knowing the increased scope of the issues. Is that my understanding?
We are going to stick with 196192 in our direct, and we'll be prepared to respond to the increased scope. I mean, as I understand your ruling here, Your Honor, it doesn't bind the commission, and we will not be arguing an additional scope in this proceeding. So we are certainly prepared to issue our direct testimony. The only reason it's not in right now is because of some contractual pre-notice requirements that came up in the last couple of days. But yes, our testimony is done. One witness, limited almost in all respects to the application that's been on file since March.
But what date can we expect? What's the soonest date we could expect the applicant to file that?
We are not able to file portions of the testimony until the 9th. Based on some contractual limitations.
Okay. So the 10th is a valid deadline.
10th is a very valid date. Yes, Your Honor. But so in the WEPCO consensus proposal, we have S&I direct on December 11th. I believe there's been some indication for some of the parties that'd like some adjustment to that. I can't remember off the top of my head, but I'll look it up what the next week is. I don't have a problem bumping the 11th to the next week of December, which would be the 18th.
Your Honor, while Attorney Proctor Brown looks up those dates, I would just add from staff's perspective, I did reach out to staff. The concern is obviously we have a limited number of staff that are able to work on these dockets, and certainly no shortage of work at the commission. And I think that's part of the reasoning, trying to fit all of these pieces together in terms of the current dockets before the commission, that commission staff wanted direct to be due after the holidays, just in terms of scheduling purposes. I would just also add that this is the continual debate where, everyone certainly, it's totally understandable, wants as much time as possible for their side, and there's always some trade-offs to be made in that respect. I would note that Attorney Proctor Brown mentioned earlier that this particular framework was the product of 2 years of negotiations. So certainly, I think it's reasonable for interveners and commission staff to have some time to look into this and formulate questions and ensure that the record that goes to the commission is as thorough and robust as possible. So I guess to your honor's earlier point, if there is the need for additional time for the applicant to respond, which is an understandable concern, I would suggest that maybe we move the back end of the schedule out further rather than trying to truncate or shorten the amount of time to prepare direct, which is really kind of the critical stage, because that's where everyone needs to put forth really their primary arguments in the docket.
Okay. Well, so
Your Honor, I would just say, so all of the other parties have said that they can get their testimony in before Christmas. I understand that staff has other dockets pending, but it just, their schedule has 103 days. I guess now it's 94 days after our one witness puts in testimony to submit their testimony, and 14 days for rebuttal for us to respond to 9 interviewers. Now, the reason that we want this to be decided in Q1 of 2026 is because then we need to do the bespoke resource agreements and the service agreements, get those before the commission for approval. Then the MISO planning year starts not too long after that. So there are follow-on activities that need to be considered when we push out the schedule, and moving the staff and intervener direct deadline to 18 days sooner, taking out the holiday period, which is for most people going to be less than full-time work, is not that much of a hardship in terms of how you prepare this case. And again, this tariff has been pending since March. The issues of these very large customers were raised in the last rate case. So the idea that staff and interveners are kind of beginning at whole cloth when direct testimony goes in is just not accurate, right? Like, there is going to be a lot more information brought from outside resources into the staff and intervener direct testimony than I think Attorney White's comments imply.
Okay, so just allow me to direct this a little bit so we can speed this process up. How much time does the applicant, and I suppose it would be, well, let me just ask the applicant, how much time does the applicant need for rebuttal between intervener, commission staff, direct, and rebuttal?
Your Honor, we think at least about 30 days makes sense, and the way we have it proposed is that includes the holiday period, right? So that's why we're at 35, just to fill that out. If you bump our deadline in our consensus proposal to the 18th or 19th, which are the last Thursday and Friday before the Christmas week, then you're looking at 27 or 28 days, including all of the holidays. We would be comfortable with that. The January 28 hearing that is in our proposal is, again, to give a little bit of time to accommodate Clean Wisconsin's deadline, and I understood all of the parties were available on that date. We never did get response from staff to this proposal, by the way. So that's the adjustment we would propose, is to bump the S&I direct deadline to either the 18th, which is the Thursday before Christmas, or the 19th, which is the Friday before the Christmas holiday. And I think that should be a very reasonable accommodation for the issues that Attorney White's raised.
Okay. This is where we used to get out the the calendar in the hearing room. Katie, you probably remember that.
I do.
All right.
I mean, you're right, Your Honor. So, looking at the calendar, right, like the way that Christmas and the New Year's holiday fall, if you bump back past those deadlines into the first full week of January, that's almost 3 full weeks. I don't know what the other parties are going to do, but I know that WEC is going to drive us hard on those dates, and so we're willing to take those potentially dead weeks at the commission as part of rebuttal, and that plays into our analysis here. But I don't think the commission is going to want to try and file anything on the 2nd, right? So you're looking at the 5th, 6th, and 7th is like the earliest dates, and it just doesn't make a whole lot of sense to us to eat up all those days kind of waiting when we can be working on testimony. All the parties besides staff agreed to have testimony in before the Christmas holiday. And then because of the way Clean Wisconsin's unavailability lands, if you start to bump back the hearing, I think you land right in the middle of where they're unavailable and really have a problem with their conflict. So I guess I would pose it to
I hear you. Okay.
Staff.
I think I'm going to ask is that we take a recess and have commission staff review this proposal. I think, let's say, pushing direct back staff intervener and staff direct back a week may be reasonable. So can I ask staff about that? And then in terms of the conflict with Clean Wisconsin, we may just have to live with that. I don't know how else to accommodate everyone in order to get this done. But
Your Honor, if we could move initial briefs back a week, that would help us a lot in terms of the conflict.
so advance it 1 week, is that
right?
Well, I don't have a problem with that, but I don't know about others. So it would be the 20th and the 27th. Is that more
correct? Right.
20th for initial?
Yep.
Well, Your Honor, I think we should. So we don't necessarily have a problem with that, but I think we should be working off of the consensus proposal, the proposal that you have up, and see if staff can accommodate all the other parties to have it before Christmas. But a week is, from my understanding from management, is the longest we could push out the end date without having to potentially take this to the commission.
Oh,
I don't have authority to agree to anything longer than a week.
You don't need to let me know that. It's irrelevant to me. But yeah, let's see. And staff may not like this either, so we may see a written appeal from them. I don't know. I don't know what to tell you. So yeah, I'm not going to start with the consensus proposal. I'm using this staff proposal, but so I think an adjustment that I could propose is that first, just to cut that intervener commission staff testimony, move that back 1 week. I don't know if we need to go into take a break for that or if staff can respond.
Your Honor, I'm checking on it right now.
Okay, let's go off the record.
Your Honor, if we could just take a quick 5-minute break for staff to confer on that.
Okay, yeah, we'll be off the record for 5. So 11:40, we'll get back on. All right, we're at 11:40. Do we have any news from staff?
On the record already, Judge, or wait?
No, let's be off the record at this point.
Okay.
Sorry about that, Your Honor. I was able to connect with staff, and I think what we would propose.
Let's get on the record. Let's get on the record now, and let's
Okay.
have staff's opinion on adjusting the date.
To Your Honor's question about adjusting the date backwards to the previous week, the reluctance about having it due on that Monday is that's right after the holidays. But
Yeah.
staff would be open to setting it on the 7th for intervener and staff direct. And then also to accommodate the applicant's concerns about having sufficient time for the rebuttal, moving rebuttal to the 28th, which would then give 3 full weeks for response.
Okay. And then in terms of I didn't ask you about this before, but we were discussing change in the brief deadlines. Can you imagine any problem staff would have with that?
I have not heard anything, so I think it's fair to say that we would not have a position on that.
Okay. Right. All right. So I'm prepared to order that schedule that as we've modified it here today. So, sorry, someone else talking? No. Okay. So we have the schedule up before us from the notice of pre-hearing conference. So I'm going to adopt that schedule with the following adjustments. I'll make the Alfred Evans Direct intervener and commission staff due on January 7th at 1:30 p.m. and the Alfred Evidence rebuttal parties and commission staff due at January 28th at 1:30 p.m. The initial brief will be February 20th and the reply brief February 27th, also 1:30 p.m. deadlines. So with that, so otherwise the schedule is as you've seen it before in the notice of pre-hearing conference. And in effort to move on before our next pre-hearing conference, let's discuss any facilitating matters. We have I've attached the what we're calling the facilitating matters ordered for contested case proceedings. Actually, according to the notice pre-hearing conference, that version does incorporate the Zoom audio supplement, so there is no separate document there that you've seen. So apologies if you're confused by that. But so the FMO you see here will be ordered in the case unless there are specific, well, if there's any comments, I'll take them and we can make adjustments to specifics if required. So let's hear from, and just in an effort to speed this up, I'm just going to unusually ask people to raise a hand in Zoom if you do have a comment to make on the FMO or have any questions about it. And I'll invite, let me just make sure I know that I'll invite people who have not practiced before us to ask questions. If this is ordered in the case, as I intend to do, this will be the requirements for filing, formatting documents. So it's highly technical and detailed, as I'm sure you'll hear from parties. But also the standardized filings, I'll be requiring you to refile in accordance with the requirements if you fail to do so. So just creates more work for everyone not to get it filed right the first time. And so appreciate people reviewing it and checking their filings before they make them check with the FMO. And also don't forget, one of the first provisions here is you can contact the assigned commission staff attorney for questions. And also if you have some filing issues, our records management division can also help you with that. I think their information should be in here, or used to be in here. Yeah, okay. So yeah, if you have problems with filing, you can contact our records management unit. So with that, any general or specific comments to the FMO? We'll take them now. I see we have WEPCO has your hand up, so go ahead, Attorney Proctor Brown.
Thank you, Your Honor. As I believe you know, we object to the FMO. We believe it's outside the scope of your authority. We would refer and incorporate here the argument that we made in our interlocutory appeal in docket 6630 ER 107. That's PSC Ref 560196. We don't view the commission's not taking up that appeal as in any way ratifying the FMO or disregarding the arguments we made in there. But I won't restate them all here. I do want to focus on 4 potential changes. As we discussed in 6630 ER 107, we view the potential restrictions on source or rebuttal as problematic. That's the FMO at pages 7 and 18. We formally agreed with Sierra Club to file source or rebuttal by 10 a.m. The day before the hearing, which I guess is now the 3rd. So we would be open to putting that formal deadline in the schedule, but do not believe other restrictions that may or may not appear in the FMO are appropriate. We believe the restrictions on motion to strike are unreasonably short, particularly given the volume of testimony we expect to get on now the 7th or whatever was ordered, and believe that motions to strike should be due the date of the next round of testimony. We believe the early deadlines for discovery responses and objections are outside the scope of your authority, as PSC2 incorporates Chapter 804 and the deadlines there. And lastly, on the NDAs, we believe it's illegal to order us to provide CEII information to parties that do not have authority from FERC to receive that information. So those are the 4 that we think are important for this docket, and I would leave it there.
Okay, great, thanks. Any other parties got hands up for questions? I know we had an issue about discovery time from one of the part interveners, but anyone else? Okay, yeah. Cub, go ahead, Attorney Narvi.
Yeah, I'll just address the point about discovery. This is a pretty expedited procedure from here on out. I think it's appropriate for the FMO in this case and others to reasonably shorten the time period for discovery. I think it's incumbent on the parties if that time is too short for a particular request, the applicant has an issue responding to work together to accommodate that. But given the short time frame remaining in the proceeding, I think that's appropriate. And I note too that Chapter 804, which is incorporated by PSC2, gives judges quite a bit of flexibility in shaping discovery, entering protective orders, making orders about the sequence and timing of discovery, and specifically giving judges the ability to shorten or lengthen the default 30-day time for discovery responses. I think if we're incorporating Chapter 804 into PSC2, then we are also incorporating the role of the judge in overseeing that discovery. So I think the 21 days under the FMO is reasonable, and it's authorized by Chapter 804.
Okay, thanks. Did anyone have a request to change the time frame? Not go to the statutory deadlines, but was there an issue about modifying the shortened time frame? I thought I'd heard that before. Is that something you wanted to raise, Delaney? We'll have you go ahead.
No, Your Honor. I was hoping to talk a little more about the procedure for confidentiality between potential competitors.
Okay, sure. So just before we do that, I did recall someone. Was Attorney EPLC?
Yeah, I'm sorry, Your Honor. Yeah, it was Brad who had raised it. I believe I believe Brad just asked that we had clarity on the deadlines.
Okay, and do we have enough? Is there enough time then, given the current schedule? So we have the 21 days for full or full despite an objection. That's a turnaround. That's before prior to the rebuttal deadline, and then after rebuttal, it's a 7-day turnaround.
Your Honor, from our perspective, the shorter deadline should apply. And this is really not an expedited proceeding for staff and intervener direct, but to be fair, the shortened deadlines should apply after staff and intervener direct. So if we issue discovery to staff and interveners after their direct in January, the 7-day deadline should apply. 5-day deadline, I'm sorry.
Your Honor, this is
where this is expedited.
I'm sorry, who's next?
This is Attorney White. I just wanted to note, looking at that 7 days after rebuttal, just based on the schedule that we had set, I believe rebuttals due the 28th
Right.
of January and the hearing is the 4th. So we may want to
Mhm.
shorten that because that 7 days would take you right up to the hearing. So there may need to be a reason to shorten some of those later deadlines.
Yeah. Okay. Okay, but to address Attorney Proctor Brown's issue with the 21-day to apply the shortened deadline to after staff direct. Issues there.
Just, this is Krista Westerberg, Judge, for clarity. So then the 7-day turnaround would apply on as after the 7th of January.
That's what's being proposed.
Okay. I guess I don't have, I can understand why a shorter deadline would be appropriate there. I just want to flag that the other interveners were not consulted on the January 28th rebuttal date, which I think, if I'm reading the schedule right, gives us 3 days to file cert rebuttal, which is a bit, 3 business days. So perhaps we would have bumped that back to the 26th or something. It's just a very, very tight turnaround.
Oh, right. We didn't address that, I guess, before.
The applicant doesn't disagree with Attorney Westerberg, which is why all of the parties besides staff agreed to have staff and intervener direct before the holidays.
Yeah, I understand. Attorney Proctor Brown, it's really not helpful. I understand the situation. No, let's just go off the record for a second here. Okay, so I have, let me just, so let's get back on the record. So in addressing Attorney Westerberg's concern about the surrebuttal deadline, I do have availability for the hearing to be conducted a week later. So we could push the whole schedule back a week. We can keep the brief deadlines where they currently exist, but move the rest of the process forward a week. So that would put the hearing on the 11th of February. Let's see,
Your
Ms.
Honor,
Brewer,
could
you
we-
had your hand still raised.
Oh, sorry.
Not regarding this issue. Sorry.
No,
Still
okay.
waiting on the other
I'm
issue.
just going to lower your hand
Yeah,
for
that's
now.
fine.
All right, so just off the record, so I can take comments on that. Who, just let me know who wants to speak first on that.
Your Honor, is it possible to move the hearing to
Let's
the?
get on the record.
Okay.
Let's get on the record. Go ahead, Katie. Sorry, I just want to make sure we have.
Yeah. Is it possible to move the hearing to the 12th?
I think so. Yeah, that's possible. Yeah.
Thank you.
So that would help you hopefully
Yes.
slightly.
Somewhat.
And then the briefs we keep the same as they are. 20th, 27th. So then we can move the surrebuttal that 1 week back, forward, whatever you want to call it. It's originally at the 2nd. So we can do surrebuttal on the 9th or the 10th. Anyone care? Okay, I'll give you the 10th for that. Okay. So I think we've solved that problem. So let's make sure we understand. So I am adjusting the schedule now one more time. Hearing will be on February 12th and surrebuttal February 10th. So with that, I guess I don't have a problem changing the discovery turnaround for after intervener and staff direct to the 7 days. So you'll see a modification for that in the pre-hearing conference memo. So basically adding that as another, well, I guess just adding it to 5B. I think just to address Attorney Narvi's concern about turnaround, I think we've always tried to adopt a standard of good, it's in here somewhere. What is it? Good faith response time, so that as you have information, you provide it. That's what's intended by that. This way, there's at least delay that you can produce documents. Discovery, the better. Okay. Anything else with the FMO? Anything? I think Attorney Brewer, you had some issues with confidentiality. You still there?
Yep, I'm here, Your Honor. I think.
Okay, there you go. Yeah.
Yep. I think the FMO is really focused on protecting records from public disclosure. Might not provide adequate protections for disclosure of information that to other parties that may cause harm. So I think, Microsoft voluntarily intervened in this case. We believe we can add value to the commission's review. As I mentioned earlier, we don't believe that any individual customer's information, specific load information, and maybe otherwise is really relevant, but we understand we may be subject to discovery, and obviously we'll respond if relevant. But I think we really need some clear expectations on the confidentiality process that's allowed with respect to these issues between potential competitors.
Okay. So between the competitors, I can order that no documents the let's see, what should we call them? The intervener data center interveners? Does that people? So I'm talking about Vonage, Microsoft, Vantage. I'm sorry. That's a telephone issue. Vontage. I've dealt with them before many years ago. Okay, so it was so we have VDA, CI, and MS, Microsoft. I think that's all of the data centers intervening, right? So we just call them the data center interveners. That no information that data center interveners claim as trade secret or competitively sensitive information be shared among those interveners. By those interveners or any other party in the case or commission staff, and that to the extent but they may be shared with third outside counsel, so an attorney's eyes only basis. So discovery of those documents should be provided. Well, let's see. So they get IRFed under the confidentiality request. They don't necessarily get shared with all parties. They're not served. Correct? Or am I getting that wrong? Well, I guess you do serve them, yeah. So if you're serving those confidential documents, you would serve them the full version only to third-party attorneys' eyes only attorneys. Otherwise, the other documents are served and IRFed according to the confidentiality process. I think that should protect cross-pollination of trade secret information to the parties, so long as attorneys are respecting that requirement. Is there anything else? Is there anything else you think you need or require in order to comply with discovery and be assured that there's adequate protection for trade secrets?
Your Honor, I can't think of anything specifically, but I mean, I want to be clear that there's really the risk and potential harm here is higher than we've seen in the past. This is a novel case, and there's a really limited recourse for inadvertent disclosure or misuse of this information. So I just want to lay that foundation with expectations on discovery.
Well, I guess what I can do, I don't usually do this, but if you want to file a proposed order regarding the third-party attorney's eyes only provision, restrictions on the data center interveners for obtaining discovery, and having access to that information, why don't you file it and I can review it? If I'll review it. I can issue an order to that extent, looking at your draft proposal.
Your Honor, this is Joe Wilson. I haven't piped up yet, but I have a procedural question on this issue. Yeah. Are you anticipating 4 versions of testimony and 4 versions of every brief so that specific customer data is protected? I mean, it quickly gets sort of ridiculously complicated.
Well, we'd have the 2 versions, confidential and redacted.
But you have to keep one customer's information confidential from the other customers.
Right, but I think we have all outside counsel for all of the data center interveners, correct?
We do.
That's what I'm looking at here. So I think if you're serving the confidential redacted and full version to those attorneys only. That's what I'm talking about, is the attorneys.
So the parties would not, like Microsoft would, business executives would not be allowed to read the briefs?
The confidential version? Well, we can do 4 versions. I mean, it's kind of like having CII versus regular confidential. It's basically the same process. So yeah, if we could do 4, but I think it would be 3 versions. But so there'd be confidential, there'd be public redacted, confidential redacted with data center trade secret information, and then confidential full disclosure document. Right?
And separate versions that contain the information specific to each customer.
And specific to each customer, right?
So I raise this as a
yeah, well,
I guess an indication of one of the reasons.
Well, I'm sorry. I'm not going back and restricting the scope of the hearing because of a complicated filing process. All we're doing is adding one more requirement to filing, and we're doing so in order to protect these companies and their trade secrets, which I think we're obligated to do. So, yes, that's how we'll proceed. I mean, we've done this before. I don't think there's much controversy here. To the extent that this information is even in briefs or in testimony, I mean, we don't know. Maybe we could set it up as an exhibit. That could be, I mean, testimony doesn't necessarily have to have the data. It could be referenced to an exhibit, for example, and then you could say, look at that. So you can try to reduce the number of versions of things if you would like, if that makes it easier. But the basic principle is yes, there would be separate versions, and we've done that before. So it's not unusual. It's not very frequent, but it's not an unusual thing that we would do. If you have a better idea, I mean, I'm sure courts have handled this before. Perfectly willing to listen to alternatives, but I think at this point, seeing a draft order on this would be useful. I don't usually have to do that, but I don't have a problem with it. So we can order a specific. I can issue a specific order about this, so that everyone's comfortable with the parameters and that they feel protected. Certainly have no problem applying the law in that fashion, but that doesn't mean we need to, flush the case down because of this. That's not going to happen. So, all right. So if Attorney Burr, would you be willing to draft something up and for my review, and I can issue an order based on that?
Sure. We'd be happy to. Can I just ask a clarifying question? And admittedly, I have not studied these new FMOs as much as some of the utilities probably, but with respect to the confidentiality agreements and the standard agreement, is the idea that is something the applicant comes up with and circulates, or is that a collective agreement? I mean, I think there may need to be some specific NDA requirements in here, even for those non-competitors who are intervening.
Yes. Okay. So it's nothing standard that I can give you. So if you look at, so we're talking about FMO B, oh no, not B, was this 2? No, 1B. Let me get down to this 7. So it's the preset NDA. Yeah, that's something. It's not supposed to change the practice. It's just supposed to advance the timing. So the way I understand that parties operate is that if a party gets a discovery request and the response has got confidential information in it, confident information that it's claiming is confidential. And when it files its information, it'll file under a request for confidential handling on our system. So if the response contains that information, it's going to the typical process would be, as far as I understand it, the respondent is going to say, I can't answer this until you sign this agreement. And here's my agreement you need to sign. That gets signed, and then the response is performed. But all this is doing is saying when you file a document that you're claiming has confidential information in it, you attach the agreement and you say, anyone who signs this agreement, any party that signs this agreement can get a copy. We will give a copy of the full version too. So it steps up, it advances, shortens that period of time. So you don't have to, so parties don't have to wait for a request to be made and then agreement to be signed and then the response to be shared. So if you're filing a document, the document should have this preset non-disclosure agreement. I've looked at FERC, and I think this is how they handle those documents. So I don't think it's really shouldn't be so unusual or such a big surprise. It's just really trying to copy the FERC process on that, so that you can respond more timely fashion. But the NDA can be whatever you want it to be. It's not, I'm not requiring anything. It's what I'm anticipating is that you use the standard one that you've always been using, if to the extent you even have a standard one that you're already using. But and then to the extent that the same information, the information of the same nature is being filed on Earth, the request, the discovery can just proceed with the understanding that an NDA has already been signed by that party. So that you just continue to process your discovery like you've done before. We have an NDA, we can continue to process that information. So it could be that you want to put a third-party attorney's eyes only provision in there, depending on the filing. I would advise you to do that because that's exactly what would be appropriate. And then in terms of CEII, I know WEPCO had mentioned the idea of CEII being that this process incurs some sort of issues with that. I don't think it does. It just says you're going to require the recipient to already have authority to see CEII before you provide it to them, which is what we do now. It's going to try to advance this process before rather than after discovery is filed. We can get this settled beforehand, and then discovery occurs quicker. So
I'm sorry, Your Honor. I just wanted to mention the CEI thing. That's not what the provision up there says. If that's your understanding, that we would only provide CEII to individuals that FERC has permitted to receive CEII, I would say we should revise the provision. It's just not what it says. But that's my understanding.
FERC doesn't authorize
You're not allowed to provide CEII to anybody that doesn't have authority to receive CEII from FERC. That's what the administrative code says on the federal level.
Well, this says, so sub E here, 7E, talks about any document that a requesting party claims to contain CEII, the applicable preset NDA shall include all provisions necessary to enable the receiving party to receive that CEII. So it could say you need to show me what your authority is. And I don't have authority from FERC to see CEII. I've signed a document, a MISO document, that allows me to see CEII. And as far as I'm concerned, as far as I know, I'm authorized to see it. I don't have an order from FERC if that's what you're contemplating. I don't understand that. And basically, there is a lot of confusion in terms of what CEII is and who can see it. But to the extent you go through the process of being authorized to see CEII, you're okay, as far as I know. So if someone signs the document that says I'm who I am and I want to see it for legitimate purposes, and then you have authority.
Okay, but that
So
was not our understanding. I don't think that's what it says in plain English, Your Honor. But if you're saying that we can make the provision of CEII contingent on review of the person's authority to receive CEII, then I think that resolves our concern.
okay. Thank you. Yeah. Okay. So yeah, okay. So I just wanted to, I don't think, and I don't know if that's going to come up here in this case, but in terms of trade secrets, yeah, you can put whatever you want in your preset in NDA. I mean, you may get complaints about what you put in there, but I think the idea is to have you set up the parameters of the agreement, like we've done in the past, in every case. It's just that you provide it with the document when you file it on Earth, so someone can just sign it and send it to you. So. Um, so if you want to put in your third-party attorney's eyes only information in there, that's fine. I think in this case, like Attorney Wilson has raised the complications here. I think it's worth just having a standing order about that as well, if you want to belt and suspenders the whole thing. So, okay, so anything else with the FMO? Right. Yeah, and if anyone can give me more clarity on CII, please feel free to contact me. But I think that's all we need for the pre-hearing. And I'll be making that adjustment to the discovery timeframe for that it will trigger after the intervener and commission staff direct a shorter time frame. So that's the only change I'm going to make to the FMO in this case.
Your Honor, if I could just ask one
Okay.
quick question.
All right. So yeah, what was that?
Attorney White's from the Public Service Commission. Earlier, there was some discussion that the applicant had said that they would commit to providing certiorari rebuttal by 10:30 the day before the hearing. And I think that date was February 3rd, but now that we've moved the hearing date, does that commitment still stand? Is that something that we were modifying?
I wasn't intending to accept or reject that. I'd rather just keep the process the way it is. Parties can certainly agree to something, but I guess I don't know how I would handle that at the hearing. Currently, I guess written certiorari rebuttal is really not. The FMO is silent on that. We have a provision that says the party can present testimony at the hearing regarding the last statements made by parties and commission staff. Let's see. And I would like, there, to the extent that it's not, I'm neither going to preclude that or allow it specifically at this point. I think it really depends on the nature of what's being proposed and the context of the case. So I think we want to look at Section 9 of the FMO. Also number 9, so 9.9. A witness may offer brief oral testimony on the witness stand and prior to any cross-examination. This testimony shall not repeat prior testimony and shall respond to the last round of the filed evidence or evidence received at the hearing. Use best efforts to avoid undue surprise or prejudice. So to the extent that parties want to agree that, and commission staff, they want to agree that written version of that will is okay. I guess I won't. I guess I won't rule on whether that's okay or not. But I think we just let things proceed the way they are. I think we won't have an issue. If people want to, in order to avoid prejudice and surprise, some sort of agreement or notice is appropriate. But I think the standard is still brief, short statements on the stand is what we're expecting. And to the extent parties and staff want to modify that, I out of context, I don't necessarily have a problem with that. So I guess I just don't know to the extent that you're going to introduce significant testimony in writing, complicated analysis, exhibits. I think we faced this in other cases and we've resolved these issues, but to order another round of testimony, I think it just goes too far in terms of setting a standard that we increase the complexity of the record without necessarily benefiting the record. So I'm going to leave it like this, and to the extent people can agree to file something, that's fine. To the extent it gets filed or it gets proposed to be filed and then I accept it, I think I usually end up doing that. So, but there's certainly no bar or yeah, I think the way it was indicated by WEPCO is potential restrictions on certiorari rebuttal. Yeah, I think there are potential restrictions. It depends on the case and the context. But I think use your understanding of our practice to inform you on that. To the extent you get agreement, that all the better. But I think because we're allowing a Zoom connection, the standard for providing documentation you're going to use at the hearing will apply. So make sure that's the one's deadline, I think, that gets imposed on any document we're going to present at hearing that hasn't been filed before. And I would emphasize that you shouldn't be filing this until after the hearing. Sharing it by email would be the practice as it's contemplated by a document you're going to use at the hearing, and sending it to me by email. But then filing would occur after the hearing. So just so you know that. All right. Anything else?
I just would have a comment on what you said said just then, Your Honor. It's my understanding that the 24-hour requirement for documents applies to an audio-visual hearing, and I don't think we've discussed the location of this hearing. We have in previous cases, like construction dockets last year. I think our position is we should go back to in-person hearings to the extent possible, and that would apply to this proceeding too. And then the 24-hour requirement, to my understanding, does not apply to in-person hearings.
Mm-hmm. Okay, so actually the schedule does indicate this is going to be a Zoom only party session. That was in the notice. So if you wanted to offer an alternative, well, I'm glad you did it now. And either way, though, if we do it on location, I would allow a Zoom connection, participation by Zoom. So in that sense, you would still have the 24-hour requirement because it's any hearing that contains a Zoom allowance for a Zoom connection. So so what do parties think? Do we want to meet in person? I'm sorry, on location, or is this a type of hearing that is something that we can conduct over Zoom only? Any opinions?
Well, the way would prefer Zoom, Your Honor. I think it would make sense in this case.
Your Honor, in case it wasn't clear, the applicants would prefer an on location hearing.
Yes, I understand. Yeah.
Okay, just wasn't sure. Thanks.
I mean, this is Richard Heineman. I would be happy with an in-person, but understand that we could and have some precedent to have combined Zoom in-person hearings. So not in-person only and not Zoom only.
Right, and that's what I would intend to do. Should we be on location, we would also have the ability to participate on Zoom.
Your Honor, yeah, I think I would prefer Zoom as well.
Okay.
And Your Honor, Steve Hines in here. I had to say that having an in-person hearing, it would be my preference, certainly, with the opportunity to use Zoom if necessary.
Your Honor, Sierra Club would support a Zoom hearing.
As would Clean Wisconsin.
Okay. Does Commission staff have an opinion on that?
No opinion, Your Honor. The only thing I would note is that with the move of the hearing date to Thursday, the 12th, logistically, that might pose an issue with use of the hearing room.
Yes, I think I didn't hear you say it, but I think you meant the an issue with the commission open meeting.
Correct. That's what I was getting at, but I guess I didn't explicitly state it.
Right, right. Okay. Yeah, okay. So that is a significant concern. Okay, so I think at this point I'm just going to have Zoom only for that on that basis to prevent any conflict with the commission meeting. We don't have the commission schedule. I can't modify the schedule again. But I think if we plan for Zoom only, um, and I don't really have a preference either way. I before the notice of hearing goes out, I can check with the commission calendar and see if they have any issues with if we'll create a conflict. At this point, I think it may be too early in that meeting date may not be set yet, but it's possible. I think there's a likelihood that we would see one on a Thursday. So I'll leave it sort of to be determined, but I think we would allow Zoom connections. I mean, we definitely will allow witnesses to appear on Zoom, and I can also allow attorneys to appear on Zoom if we do switch over to on location hearing. It's just too early to tell whether we'd have the room available on that day. So we'll leave it Zoom only for now. But just to clear up the any doubt, because we will have a Zoom connection. There's the 24-hour filing sharing of documents would still apply, and I think it's 24 hours. I have to check the exact language now on the FMO. I'm not going to do that now, but it's in there. So just follow what's in the document. Okay, so any other issues? All right. Well, thanks everyone for your. Oh, and did I? I'm sorry. Also, let me just address the other concerns that WEPCO had with the FMO. So restrictions on motions to strike. So yeah, the appeal from WEPCO and on another docket was complaining about a 5-day turnaround for a motion to request to strike testimony. So in the pre-hearing conference in that docket, that was raised as well. But originally the deadline was 3 days, and I did extend it to 5 days. So I can, we'll see how that works. I think I was, trying to be more flexible by increasing the time frame. I do want to see those motions filed before the next round of testimony. But the 5-day deadline right now is where we'll set that at. And I think that's all the things that we haven't addressed yet on the FMO. So, great. Anything else? Okay. Well, thanks everyone for joining. We are done and we are adjourned. We'll see you in February.
Thank you.
Thank you.
Thank you, Your Honor.
Thanks.
Thank you.
Thanks.